Hi, I'm Elizabeth Talbot, and I'm the estate planning coordinator and paralegal with the Talbot Law Group in Walnut Creek, California. So today I'm going to talk about subtrusts, specifically the survivor's trust and the decedent's trust for a joint revocable trust. Okay, so let's start out with the basics. First, we have a couple, and they create a joint settler trust. That means there's two of them, they're holding the trust together. Now, generally during their lifetimes, that trust document that they've put together is revocable, meaning they can change it or they can just do away with it altogether. But there are certain kinds of trusts, and what happens when one person dies is part of that trust becomes irrevocable. Irrevocable means it cannot be changed or done away with. Now, why would you want to make part of that trust irrevocable? Well, situations where this is common is maybe where there's children from a different marriage, not of that couple. So the parent of the different children or child wants to protect a certain amount of the assets for that child, whereas the new spouse may not have the same interest in protecting those assets for that child from a different marriage. So often what they'll do is create one of these kinds of trusts where part of it becomes irrevocable upon their death. Now, that doesn't mean that the surviving spouse cannot use those assets for their care. Generally, the way we set it up is that during the lifetime of each spouse, for their entire lifetime, whoever should die first, the other one is still cared for and their lifestyle is maintained by all the assets in the trust. However, they cannot change the final distribution of a portion of that trust. So if a couple has $1 million, let's say, and one of them dies, so the spouse is left with $1 million. They can use that $1 million generally however the trust lays out that they have permission to. But let's say 500,000 of that, they cannot change the eventual beneficiary of that money. So if that 500,000 is still left when the last spouse dies, it will go to the beneficiary that the original first spouse to die had designated. So it allows for freedom while protecting money for the eventual beneficiaries. Because there's another way to do that, and often people who have children of the same marriage do it this way, which is that there's $1 million after one spouse dies, let's say, and they can use that money for their benefit during their lifetime, and they can also change the distribution and the beneficiaries of that money. So none of it's really protected. They can do whatever they want with it and make a change to their estate plan after one spouse dies. Now that allows for a lot of flexibility, which can be really important. So you have to weigh with your estate planning attorney which one is better suited for you and your family. If you have more questions, feel free to call us and we'll be happy to help you. Thank you so much.